Institute. Welcome to everyone. Please make yourselves comfortable. There's food outside for those of you who haven't found it yet. Our guests will be here in the next 15 to 20 minutes or so. We're running just a little bit behind, but we will get started as soon as we can. Thank you very much. Oh, okay, sorry. Did everyone hear me? Our guests will be arriving in 15 to 20 minutes. Thank you. can see it here, and then you can give your comments.
Great.
And then we'll have Q&A.
Perfect.
Hello, my name is Harold Furchtgott-Roth. Welcome to the Hudson Institute. We have a wonderful program today for you with Commissioner Noah Phillips. Just a quick note, this Friday we will have Professor Jonathan Baker of American University Law School, who will be discussing his new book on the antitrust paradigm. This is Antitrust Week at Hudson, it appears. But today we're honored to have with us Commissioner Noah Phillips of the Federal Trade Commission. Commissioner Phillips has represented all parts of the country, I have to say. He's an undergraduate on the East Coast at Dartmouth College, has his law degree from Stanford, worked on Capitol Hill for many years, including as chief counsel for Senator Cornyn of Texas. Throughout all of that, he has gathered a wealth of experience about matters related to antitrust, consumer privacy, consumer protection, all of the things that the Federal Trade Commission addresses. It is arguably the place to be, I think, right now on a lot of fronts. And he's going to be speaking to us today about breaking up is hard to do, or whatever topic you want to speak about. Commissioner, welcome to Hudson. Thank you so much for having us, for joining us.
Thanks for having me.
You're welcome.
Okay. So thanks again, Harold, for the introduction, and thanks to the Hudson Institute for hosting me this afternoon. It's an honor to join the substantive policy conversation that Hudson has fostered for more than half a century to contribute to the important work that you're doing here at the Center for the Economics of the Internet. The fact that terms like network effects and creative destruction are the subject of frequent punditry these days testifies to the timeliness of that work. Before I go any further, I want to start with a really important caveat, and that is the remarks I'm going to give today are my own opinion, and they are not necessarily the opinions of the Commission as a body or any of my fellow commissioners. The populism enthralling left and right in American politics today is bringing renewed focus to antitrust law and policy. Some of the concerns that underlie this renewed focus may be real. Scholars point to indicia of increasing concentration in industry. Economic gains are not always shared broadly. And those gains often come from growth that disrupts businesses and jobs alike. There is nothing wrong with taking a look at the state of law and policy and, like Chesterton's fence, asking why it is where it is. But there is everything wrong with pushing dramatic changes to either without due consideration of the answer. These days, quite a few editorial and opinion pages alike choose histrionics over history, the history we should consider, sounding alarms about antitrust and its alleged responsibility for the rise of fascism or feudalism or a new Gilded Age. Any historical metaphor will apparently do. American corporations, we are told, represent a clear and present danger to American capitalism and democracy. Less concerned, meanwhile, about those openly and notoriously advocating for socialism. Such is our discourse, as politicians and pundits alike call for the breakup of American corporations, too often without giving the serious consideration to what everyone ought to agree is a serious matter. This may make for good politics or good publishing, but I don't think the way we talk about the issue furthers good policy. So today, I want to add a little history and learning to this conversation, to add a bit more nuance to our talk about breakups. I want to talk about what people mean when they call for breaking up monopolies. When is it appropriate? What does history tell us about government attempts to do so? In antitrust speak, how have structural remedies been applied in non-merger or anti-competitive conduct cases under Section 2 of the Sherman Act? I know not everyone here specializes in antitrust, so let me define some terms and provide some background. First, the law. Since 1890, Section 2 has condemned every person who shall monopolize or attempt to monopolize or combine or conspire to monopolize. The Supreme Court interprets the monopolization offense to require both monopoly power in the market at issue and anti-competitive conduct. Just being a monopoly and even charging monopoly prices are not themselves violations, because monopoly may be achieved through competition on the merits, which benefits consumers and society. To break the law, to warrant any remedy, including a breakup, you need both to be a monopolist and to take anti-competitive action, conduct, to acquire or maintain your monopoly. Second, the remedies. Antitrust law exists to remedy failures in well-defined markets, not to structure markets according to a central plan. As in any kind of law enforcement, we should target the remedies that we seek at what the law prohibits, what we seek to stop. A structural remedy seeks to change the structure of a firm or a market, say by breaking it up in some way, like a divestiture or a dissolution. The most common example of this is when, as a condition of approving a merger, an antitrust agency requires the merging companies to divest an asset. A behavioral remedy, as opposed to a structural, by the way, targets a firm's conduct by prescribing certain practices and/or requiring others. Today, we are not talking about mergers. While Section 2 has been applied to mergers in the past, its requirement of proving monopoly, the Hart-Scott-Rodino pre-merger review process, and the Clayton Act's explicit applicability to pending mergers mean that most Section 2 cases are conduct cases. The non-merger or anti-competitive conduct cases at issue here today exclude those in which a divestiture is ordered to remedy a pending or recently consummated merger. In merger cases, a structural remedy preserves the market structure. In conduct cases, it disrupts it. Where conduct triggers Section 2 liability, antitrust agencies and courts almost always seek behavioral remedies. We seek to stop the illegal conduct. And the idea is simple: fix what's preventing competition and then let firms compete. For example, a week and a half ago, the FTC sued a company called SureScripts under Section 2 for monopolizing the e-prescription eligibility and routing markets. All 5 FTC commissioners voted to sue the company and to seek a behavioral remedy to stop SureScripts from conduct that we allege is preventing competition. We target illegal conduct, not companies we don't like. So identifying the conduct and stopping it is the preferred approach to Section 2 violations. It is far from obvious, at least to me, why structural relief is necessary to stop behavioral problems. Why, if our goal is to stop bad conduct, is breaking up a company the way to go? What does a breakup accomplish that an injunction cannot? Even if one sidesteps these thorny questions, we still need to grapple with the fact that, to borrow from Judge Frank Easterbrook's famous 1981 article, breaking up is hard to do. Using antitrust to break up companies was never common practice in US history, even in the law's early days. Of the single firm monopolization cases brought by the government, less than 20% resulted in a substantial divestiture, whether the sample runs from 1890 through 1939 or is extended to 1999. Focusing only on non-merger cases, the percentage drops below 10%. The most famous breakups are Standard Oil in 1911 and AT&T in 1984. The contrast between the two are instructive, but neither experience should whet our appetite for breaking up companies without a good basis and the right conditions. You might be surprised to learn that the breakup of Standard Oil, the infamous Rockefeller Oil Trust, formally ended earlier this month, when the Department of Justice moved to court to end the 1911 decree from 108 years ago. The government sued Standard Oil under Sections 1 and 2 of the Sherman Act. The complaint alleged that the Standard Oil Company of New Jersey, later Exxon, some 70 subsidiary corporations and partnerships, and 7 individuals conspired to restrain trade in petroleum, refined oil, and other petroleum products, and attempted to and did monopolize those lines of commerce. The lower court held the defendants liable under Sections 1 and 2 and ordered the dissolution of Standard Oil. The Supreme Court affirmed the breakup ruling. The first thing the history of Standard Oil teaches is that it was not so much a case about anti-competitive conduct. The breakup remedy was really aimed at the combination it sought to undo. Standard Oil was, at the time, a New Jersey corporation that became the repository of stock following the Ohio Supreme Court's 1892 dissolution of the original Rockefeller Oil Trust. While the U.S. Supreme Court's opinion is sometimes difficult to follow, it grounds liability both in the combinations creating the trust and in conduct including rebates, preferences, and other discriminatory practices in favor of the combination by railroad companies, and unfair methods of competition, such as local price cutting at the points where necessary to suppress competition. Those are quotes from the case. The court expressed general support for remedies that would bar Standard Oil from anti-competitive conduct in the future, presumably including those rebates, preferences, etc., that I just mentioned. But when justifying the breakup, the grounds it gave were that the trust's creation violated the law, stating, so far as the decree held that the ownership of the stock in the New Jersey Corporation constituted a combination in violation of the first section and an attempt to create a monopoly or to monopolize under the second section, and commanded the dissolution of the combination, the decree was clearly appropriate, end quote. So, while the Supreme Court affirmed Standard Oil's antitrust liability based on the combinations creating the trust and the exclusionary conduct, the illegality of the trust's 1882 formation and subsequent reorganization were essential to the breakup remedy. While a few subsequent cases have applied structural remedies in response to single firm conduct, and AT&T, as we'll talk about, is one example, Standard Oil, the most famous breakup, may not be such a compelling precedent for a conduct case. The court not only required monopolization, it required the combination it would unwind have caused it. Another thing about Standard Oil, it's not clear that the remedy worked. While the breakup is historically significant, the evidence it served those it should have, consumers, is not encouraging. First, the dissolution spun off the stock of each operating company within the trust to Rockefeller and his associates, the same group who had owned the trust stock. Second, by simply undoing the holding company, the decree produced an industry structure that was largely a product of Standard Oil's pre-breakup corporate organization. As Judge Richard Posner has pointed out, quote, the decree had substituted a series of regional monopolies for a national monopoly, end quote. How that spurred competition is far from clear. One attempt to measure the breakup's economic impact has found a negative effect on output in 1912. And pretty much the FTC's first job upon its creation in 1915 was to issue a report addressing a dramatic increase in gasoline prices. I am not saying that the dissolution harmed competition, but the evidence that the Standard Oil breakup significantly increased competition or benefited consumers is not compelling. Third, by 1911, the American oil industry was already getting more competitive on its own. Standard Oil's market shares in crude oil and gasoline had been declining even before the district court's decision in 1909, falling from about 85% at the beginning of the 20th century to about 65% in 1911, 1912. Its competitors, led by firms like Union Oil Company, the Gulf Oil Corporation, Sun Oil, and the Texas Company, now Unocal, Sunoco, Texaco, sourced from vast, newly discovered finds in Oklahoma, Texas, and California, areas where Standard Oil lacked a strong presence. By 1911, these areas accounted for a majority of the nation's oil supply. In other words, by the time the law ordered Standard Oil broken up, market forces were dissipating its dominance. Not only did it accomplish little in terms of competition, the breakup may not have been necessary at all to getting rid of the monopoly. The next breakup on which I want to focus is AT&T in 1984, perhaps the other most significant use of Section 2 to split up a large American company. The DOJ filed its complaint against AT&T in 1974, alleging that the company, Western Electric, and the Bell Laboratories had violated Section 2. The government claimed that an unlawful combination and conspiracy between the defendants, the Bell operating companies, the Baby Bells, and others, which allegedly allowed AT&T to maintain control over the two other defendants and the Baby Bells, to limit competition from other telecom providers, and to maintain monopolistic manufacturing and purchasing relationship between Western Electric and the Bell system, end quote. The discovery process lasted 7 years, with the trial beginning in January 1981. Many months later, but still 1 month before the very long trial was scheduled to end, the parties agreed on settlement terms that were approved by the court with modifications in August of that year. The final decree was complex and multifaceted, so I will focus on the provisions relating to the divestiture of the Baby Bells and its impact and their impact on long-distance services. The purpose of the breakup was to boost competition in this market, not competition between the Baby Bells, which were to become regional monopolies. The government's theory was that owning the Baby Bells allowed AT&T to foreclose competition in long-distance services and telecom equipment by denying long-distance competitors the necessary local interconnection to the Baby Bells. So, in addition to splitting them up, the decree also required the Baby Bells to make their switching facilities equally accessible to long-distance providers. Judge Posner called the breakup of AT&T arguably the most successful structural remedy in US antitrust history. He was speaking in relative terms, and I think he's probably right. There is strong evidence and broad consensus that the telecommunication industry's competitiveness increased following the 1984 breakup. As with Standard Oil, the divestiture's effects are difficult to isolate because the telecommunications industry experienced unrelated changes like deregulation and new technologies around the same time. Unlike Standard Oil, however, AT&T's high pre-divestiture share of the long-distance market had been stable and fell significantly after the breakup as competitors entered or expanded. That suggests the divestiture achieved gains that market forces and regulatory measures had failed to deliver. Through the organization of the Baby Bells and the regulatory structure of the organization of the Baby Bells and the regulatory structure of the telecommunications industry played significant roles. Recognizing the success of the AT&T breakup, it's helpful still to consider the breakup relative to alternatives the government might have sought, in particular requiring AT&T to offer interconnection on fair and non-discriminatory terms to all telecommunications firms. I mention this approach because of its similarity to the platform neutrality proposals popular in some camps. While this approach raises its own concerns, it helps to frame the question of exactly how much competition the breakup remedy injected at the margin. Studies comparing post-breakup developments in US telecom markets to those in Canada and the EU, after those jurisdictions mandated equal access interconnection, find similarly robust entry and erosion of incumbent market share without breakups. These analyses are subject to reasonable criticisms, but they highlight a question I asked earlier. Why in a conduct case is breakup better than a behavioral remedy? A side note about administrative costs. One often mentioned advantage of structural relief over behavioral is that the former requires less oversight by agencies and courts, less regulation. But AT&T shows us that this is not a given. The breakup created a system in which calls had to be routed from one local exchange carrier to a long-distance carrier and then to a different local exchange carrier. Regulating these interconnections required ongoing oversight by the court, the FCC, and the DOJ to ensure appropriate rate setting and access. Let me clarify. I'm not claiming the behavioral remedy would have avoided these costs. Any scheme based on interconnections would have presented similar challenges. Rather, I see two takeaways. First, structural relief, especially relief that restructures a market, unlike in the merger divestiture process, can be just as costly to administer as behavioral alternatives. Second, whether structural remedies are less costly depends on the case, including the resulting market structure, the technology, and the applicable regulation already in place. The lesson is that, outside the merger context, we should resist a knee-jerk preference for structural remedies based on assumptions about administrability. While Standard Oil and AT&T are not the only cases in which Section 2 was used to break up American businesses, they are considered landmarks. And contrary to what that status implies, however, taken together, they hardly suggest the remedy is something that ought broadly to be applied. and certainly not without regard to the conduct at issue or the nature of the business. I don't have time to discuss the other Section 2 breakup cases here today, but evidence suggests that structural relief has not in general fared well. That history also shows breakup remedies like these are exceedingly rare, and so the government has much less experience with them. It's little wonder then that agencies and courts alike are not, like some politicians and pundits, chomping at the bit to break up companies. While the law contemplates doing so, and doing so sometimes is warranted, enforcement experience and economic research show us that the treatment may be worse than the disease, and in some cases, simply not doable. Seeking a breakup remedy in an antitrust case requires a judgment that the resulting market structure will leave competition and consumers better off. Consider that for a moment. Breaking up a company is quite directly the government using the force of law to substitute its vision for how an industry can and should be structured for how the market has actually worked. That alone should make one pause and appreciate the gravity of the proposal. Antitrust enforcers are not industrial planners. As Judge Easterbrook wrote, we should not fall prey to the nirvana fallacy, the belief that if a cost or flaw in existing affairs can be identified, it must follow that some other state of affairs, the remedy, is better, end quote. When we seek a divestiture in a merger case, we know how competition looks. The remedy seeks to preserve the competition as it is or recently was, not an untested state of affairs that we regulators may believe superior. Although some uncertainty remains in merger cases, it is far less than the uncertainty of breakups in non-merger cases. In a non-merger case, if we wish to restructure a market, why do we presume that our vision for how that market ought to work will in fact work, much less actually work better? These are tough questions, and antitrust requires that they be answered only by one agency and one or a few judges. My argument here rests on the small c conservative principle that the greater the proposed interference with the status quo of a complex system, like a market, the less confident we should be of the desired outcome, both that it will be the outcome and, if so, that it will be desirable. This principle acknowledges the nirvana fallacy and counters with a sober assessment of our limited ability to control complexity and guard against unintended consequences. Courts require us to adopt this sensible approach. In U.S. versus Microsoft, the U.S. Court of Appeals for the D.C. Circuit overturned the trial judge's breakup order, explaining, quote, divestiture is a remedy that is imposed only with great caution, in part because its long-term efficacy is rarely certain, end quote. It went on to require, quote, a clear indication of a significant causal connection between the conduct and creation or maintenance of the market power, where the remedy is structural relief, end quote. This is the first critical lesson, and it harkens back to Standard Oil. We need a clear link between the cause, the conduct or the combination, and the monopolization, where breakups are at issue. It's not enough to point out conduct you don't like, even anti-competitive conduct. It has to be linked to the firm's market power. Just explaining how a breakup will solve a conduct problem is not easy, much less actually proving it, which, by the way, is what we as agencies need to do. The conservative principle also plays a central role in distinguishing breakups for anti-competitive conduct from divestitures for anti-competitive mergers. This remedy directed at conduct aims to bring competition where bad conduct has prevented it. But the link between the bad conduct and the remedy, and then between the remedy and the competition we hope to have, is far from obvious. To argue for breakup as a remedy, one must show at a minimum that the market structure contributed to the harmful conduct, that the breakup is very likely to enhance competition and benefit consumers by eliminating the bad conduct, and that behavioral alternatives do not offer equal or greater expected benefits at equal or lower costs. The DC Circuit in Microsoft faulted the lower court for devoting, quote, a mere 4 paragraphs of its order to explaining the reasons for the remedy, end quote. Which brings us to the second lesson. You need a lot more information to determine whether a breakup will help solve anti-competitive conduct. The goal, by the way, is to solve the problem, not to punish the wicked or bring low the mighty. Antitrust is not a biblical morality play. It's about solving specific problems, market failures that we can prove in court. Unlike in a merger case, where you prove liability by showing a likelihood of lessened competition from the change to the existing market structure, a liability determination in a Section 2 case may well indicate that the illegal conduct reduced competition. But the liability finding offers scant guidance how the market would look absent that conduct. So determining that a given remedy, say a breakup, will help is another matter entirely. Breakups also present considerable practical challenges. First, along what lines will you divide the firm? The breakups in Standard Oil and AT&T were at least relatively straightforward in this respect. They were distinct and largely independent business units to separate from each other. But many firms lack the clear lines related to anti-competitive conduct. In the 1947 case against United Shoe Machinery, the government prevailed on liability and asked the court to dissolve United into 3 separate manufacturing companies. The judge refused, on the grounds that United conducted all manufacturing at a single plant, quote, with one set of jigs and tools, one foundry, one laboratory for machinery problems, one managerial staff, and one labor force. It takes no Solomon, the judge concluded, to see that this organism cannot be cut into 3 equal and viable parts. And you don't need to be Solomon to realize that proposing identical and drastic remedies for businesses that look nothing alike probably isn't taking into account the facts of the case. How does a fair judge get comfortable? They weren't in Microsoft. Second, even if a breakup is possible, what will become of the resulting pieces? The breakup will fail unless separated entities survive in their respective markets. Otherwise, the welfare effects would be unambiguously negative. That's not so easy. The FTC and DOJ have regularly dealt with this challenge when implementing structural relief in merger cases. The goal is to maintain the competition the merger would have eliminated, which requires that the divested assets remain in the market at their current competitive strength for the foreseeable future. Repeated experience has crystallized certain lessons, showing that much labor, care, and information are necessary, but not sufficient conditions for successful breakups. We know, for example, that divestitures of an ongoing business are more likely to succeed than divestitures of some lesser bundle of assets, even if there is a buyer for those assets. And even then, success is not guaranteed. In 3 recent merger-related divestitures, the divestiture buyers went bankrupt or otherwise dropped out of the market. All these challenges and risks of actually following through are at least as acute in the non-merger context. The Standard Oil and AT&T experiences and my discussion up to now illustrates to me the speculation and difficulty involved in realizing some of the putative gains of breaking up companies. That is only the benefit side of the equation. Antitrust enforcers like me also should consider the costs. I mentioned administrative costs earlier, but breakups can also reduce efficiency and incentives to enter and innovate, with consumers ultimately paying the price. Bigness and high market concentration may be the result of anti-competitive conduct, but they can also stem from factors that increase welfare, such as superior products or services, lower costs, and quality-adjusted prices, and more successful innovation. Both EU Competition Commissioner Vestager and Professor Herbert Hovenkamp, a leading antitrust scholar, raised this point when expressing serious doubts about recent calls to break up large tech firms, noting that many of these firms have grown to competitive or even zero pricing, high customer satisfaction, and because a lot of people like their products. That's quotes that they've given. The basic difficulty in non-merger cases is knowing the extent to which the defendant's market power is a function of efficiency and competition or of antitrust violations. Where the former, the remedy can be harmful, and breaking up breaks even more. Vertical integration, that is, having a single firm at least 2 different levels of production, is another source of potentially significant efficiencies that a breakup may eliminate. A substantial body of economic literature indicates that vertical integration eliminates double marginalization. We just say EDM because it's easier. Because the firm has the incentive to sell to itself at cost, which in turn places downward pressure on the firm's prices to customers. Vertical integration also overcomes coordination problems and conflicting incentives between unintegrated firms that cannot efficiently be addressed by contracts. Vertical integration has thus produced lower cost and prices, greater product innovation, and better quality for consumers, motivating some economists to oppose the government's proposed vertical breakup of Microsoft. Economic studies of vertical integration have found that under most circumstances, this is a quote, profit maximizing vertical integration decisions are efficient, not just from the firms, but also from the consumer's point of view. The economic evidence against breaking up vertical integration is also very compelling. LaFontaine and Slade's review of the literature found, quote, clear evidence that restrictions on vertical integration that are imposed on owners of retail networks are usually detrimental to consumers, end quote. Breakups can also reduce the incentive to innovate, an important part of competition. Markets characterized by high rates of innovation and product development may remain highly concentrated or even monopolized, but still be competitive, as firms try to out-innovate each other for temporary market dominance, creative destruction, in the words of Joseph Schumpeter. Many innovation markets also display network effects, meaning that the product becomes more valuable to consumers relative to competing products as more consumers use it. Telephone networks, software, and online platforms, and networking sites are common examples. While generating benefits, network effects can also create lock-in. They can create path dependence and high barriers to entry, because firms that gain significant market penetration early may enjoy significant advantages over laggards, and because most or all of the market may eventually tip to an incumbent who can only be dislodged by a superior product or significant cost advantage. The SureScripts complaint addresses this issue head-on. At the same time, high payoffs for achieving dominance, maintaining dominance, or stealing dominance can spur innovation and competition. Note that, in these circumstances, market power is the payoff, and what look like profits above the competitive level may actually be recoupment of high expenditures for entry or innovation. Both law and economics recognize the importance of this innovation-promoting dynamic. In Trinco, Justice Scalia explained, the opportunity to charge monopoly prices, at least for a short period, is what attracts business acumen in the first place. It induces risk-taking that produces innovation and economic growth. To safeguard the incentive to innovate, the possession of monopoly power will not be found unlawful unless it is accompanied by an element of anti-competitive conduct. And in endorsing the behavioral consent, that is, not the breakup, in Microsoft in 1995, Nobel laureate economist Kenneth Arrow likewise observed, notice that most of the steps in the dynamic process leading to monopoly or imperfect competition are steps in which the growth of the monopoly arises by offering a cheaper or superior product. Any set of remedies is likely to be of the form of penalizing whatever firm happens to be leading, Microsoft in this instance. This may take the form of disintegrating the firm horizontally or vertically, or of imposing constraints on its ability to enter markets. A rule of penalizing market successes that are not the result of anti-competitive practices will, among other consequences, have the effect of taxing technological improvements and is unlikely to improve welfare in the long run. We would do well to heed these warnings. To be clear, in the face of uncertainty as to whether a defendant's actions were pro-competitive or anti-competitive, behavioral remedies run a similar risk of prohibiting or discouraging firms from acts that generate efficiency and promote consumer welfare. The key distinction is that behavioral remedies are more narrowly tailored to the specific conduct at issue, whereas the impact of structural relief is far more dramatic and has consequences well beyond the conduct at issue. Taking care not to condemn pro-competitive conduct and taking care to minimize the fallout when we mistakenly do are not mutually exclusive. We should do both. I've covered a lot of ground today and also resisted Marco Rubio's impulse to jump for the water. But I want to end by summarizing my main points. First, the historical record contains no golden era where breakups were the preferred remedy for Section 2 violations and provides scant evidence that breakups are superior to more targeted behavioral relief. Second, The legal burden for justifying a breakup is, and should be, high. Third, for a variety of reasons, structural relief presents highly uncertain benefits and risks considerable costs, in many ways more so than behavioral remedies. Finally, breakups should be a last resort in non-merger cases, and they should be pursued rarely and with great care. Taking care is necessary in law enforcement and in fashioning the public policy that drives it. A predicate to that is taking care and understanding the very real considerations and consequences that attend politics, in this case with regard to antitrust. I hope this talk has helped that conversation along, and I look forward to continuing it with all of you. Thank you.
Commissioner, that was an extraordinary talk. I think it's probably one of the most academically rigorous talks we've had in our series, and thank you very much. I'm gonna ask a couple of questions, and then I'll open it up to the audience. Of course, all of these cases, whether Section 2 or mergers, depend on market definitions. And I know a lot of new technologies today create, there are new markets out there, new markets that have led to wonderful innovations and wonderful things for consumers. How does the Federal Trade Commission look at new markets that are out there, whether it's in the context of Section 2 or mergers or consumer privacy or other issues?
So I think the basic answer to the question is, as we always have, we look very carefully. The distinction in my mind that you drew about new markets has to do with doing the best job that we can to look at, when is the new thing that is created a market? We apply a standard set of tools, in a given action or investigation. We'll talk to lots of market participants. We'll do economic research. We'll test the market for sensitivity to price increases. Do people find substitutes elsewhere, and at what level? But the context of new markets, and in particular the kinds of markets I mentioned earlier, where you have found and you might hope to find or expect to find Schumpeterian rivalry, right? Where one firm has everything and then another firm comes and takes everything. We're having a really broad discussion right now at the FTC about asking questions. Are the traditional tools that we are using the right tools? Mm-hmm. One question that came up in one of the hearings, this was from an economist at Yale, Fiona Scott-Morton, that I thought was really interesting, is asking, in our sort of traditional model of perfect competition, firms are many and they're horizontally competing with each other. But what if the competition we should be looking for is happening at a different stage? Is that true? And if so, how do we spot it? So we're applying a set of rigorous and traditional tools, but we're also taking a lot of time right now to look at those tools and ask, are they getting it right?
Great. No, I know there was the recent set of hearings on online markets and privacy. And what was your takeaway from those?
My takeaway is that I need to spend more time reading. No, we're in the process. I mean, the hearings actually remain ongoing, and the comment period remains open, I think, till June. And folks are really encouraged to sort of be involved in that. It is a process not just for us, and certainly not just for lawyers or economists. Although we very much value hearing from all those folks. You mentioned earlier, Harold, in your introduction, that the FTC is in some sense the place to be. I think part of the reason, I agree, part of the reason for that is both antitrust and in particular on the consumer protection side, privacy, are matters of public discussion in a way that they haven't been in a long time. I think that's a healthy discussion. What I'm trying to encourage is that it be a rigorous one, right? And that we take into account the history and not just sort of take taglines. And I have completely winded my way out of your question, which I have forgotten, and I apologize. No, but you can ask it.
No, let me move on to something else, which is you've discussed extraordinarily well the difficulties of structural remedies, and it is striking how few there have been and how disastrous they've been in cases. There's a related issue which applies to both structural and behavioral remedies, which is the ability of courts to govern consent decrees. And some that I'm most familiar with, whether it was the AT&T consent decree in Judge Green's court, or the ASCAP and BMI consent decrees in New York, I feel sorry for the judges in charge of those consent decrees. They're put in an impossible situation. They do the best they can, but it's not a good situation. Any thoughts about how to enforce consent decrees without people having to go say "Mother, may I" to a court every time they have something that comes up?
That's a great question. As you well know, and some in the audience made it, the Department of Justice is undertaking a really big process right now to look at consent decrees. You mentioned BMI, ASCAP, that have been around for a very long time, and figure out whether they're still warranted under new market conditions. I think we need to take into account the limitations of judges when we think about how to write them. I think we ought to take into account reasonable expectations for how markets change over time, and considering the length of consent decrees. That's another aspect of them. One of the things we like to say in antitrust is that it's about letting competition happen, that we're less regulators than we are law enforcers. Well, judges aren't great regulators either. I think we need to take that into account. But one thing I want to go back to from the speech,
Sure.
Which I think also is important, is that one of the benefits, especially in a conduct case of behavioral, really that's what I'm talking about, conduct cases of a behavioral remedy, is that you can target it more clearly at the conduct in question. Whereas a breakup remedy, again, it may be warranted under certain circumstances, and some have worked, some have really not worked well, but a breakup remedy destroys a lot more with it.
Yeah.
And so I think that's got to be the part of the weighing too. What I will say, and you've heard this both from the Department of Justice and from the Federal Trade Commission, is that in merger cases, where we really know how the competition looks, there is a strong preference for not having, a strong preference for the structural relief.
Yes. Yeah, we've heard that from Assistant Attorney General Del Rahim and others. Just a quick question about the empirical evidence. And as you were talking, it struck me, you referenced Judge Posner, Judge Easterbrook, some academic studies. Is there, within either the FTC or the Antitrust Division, is there kind of an empirical catalog of what happened ex post facto with structural remedies here, behavioral remedies here? How do these work out over time? Or is it just in the academic literature that we have? Is there a formal record?
I don't know that there is a record in the way that you're asking, but a few years ago, the FTC did a pretty comprehensive study of the efficacy of remedies in merger cases. And when I was talking before about even in merger cases where you've got like this asset and you've got a buyer and the buyer's in the market, we were finding cases where that was failing. And we studied it and we looked, and the best thing to do is when you can take, and again, Standard Oil and AT&T would be examples, you take a business and you put it out. That has a better chance of success than my giving you, X, Y, or Z unbundled asset.
And just as an aside, some that I'm familiar with that did fail were, I don't know how to put it politely, let's just say government agencies, either in the US or in Europe, predetermined who was going to be the buyer. And it turns out that actually doesn't work well. And it's sort of having an open auction for assets as opposed to the government deciding whether openly or not, who's going to be the buyers.
Well, I'll say this, if you're considering a structural remedy, let's say in a merger case, and the parties, let's say, have a proposed buyer, you want to poke it, right? You want to test it.
Absolutely.
You want to do the
I
best.
think you also want to have multiple bidders as opposed to just, someone calls up and sort of says, you're going to be the buyer of this asset. And unfortunately, that has happened in the past. Well, I don't want to monopolize the question because this is all about competition and making consumers better off. So you all are the consumers, and please, this is a great opportunity to ask Commissioner Phillips questions. We have two questions here.
Leah Nyland from MLEX. Hi, Commissioner. One of the things that the chairman has said that you all are looking at is potentially using Section 2 for monopoly maintenance cases where a company has actually bought another company in order to maintain its monopoly. So looking at past mergers through the sort of Section 2 lens. What are your thoughts on that?
So a few thoughts, not necessarily in coherent order. The first thought is that, remember, the Sherman Act precedes the Clayton Act, right? So, and as Standard Oil illustrates, it can be applied to mergers. I mean, the combination that begat the Standard Oil litigation, and which I've argued is really what inspired the breakup remedy, happened quite some time before. And Section 2, right, says, it's acquire or maintain the monopoly. So that is something that can work in violation of the law. There are also times historically, in particular, let's say a recently consummated merger, right? A merger that didn't trigger a Hart-Scott-Rodino review, something like that. Hospital merger is a good example of this, where things have merged and we've gone back and we've looked and we've determined it was anti-competitive and we've brought enforcement action. To me, some of this is a temporal distinction. So the things about which I worry become greater over time, right? The ability cleanly to, again, it depends on the business, it depends on a lot of factors, but the ability cleanly to break up may be harder 20 years in than it is 20 months in.
Great. Yes.
Thank you. M.A. Torbe, I'm retired PTO. First of all, thank you so much for taking the time out of what I'm sure is a very packed schedule to speak to us today.
Absolutely.
I have a general question. What determines when the FTC, your agency, handles an antitrust case as opposed to when the DOJ does?
This is the greatest question. We call it clearance. So the two agencies, with a few exceptions, don't have statutorily defined lines. And the basic answer to the question is, over the years, different agencies have developed expertise in certain areas, and usually a case goes where the expertise lies. So a pharmaceutical merger, that's an FTC thing, or almost always going to be an FTC thing. So there's a few statutory lines, but I'm simplifying a little, but basically it's like demonstrated experience over time in the relevant market. Yes, oh, sorry, that's a very good point, right? We don't have any criminal authority.
Up here in the front.
It's been widely discussed at the FTC New Tech Task Force that part of its job is going to be reviewing past mergers and seeing if those need to be broken up. So kind of hearkening back to your speech, is that not going to be one of its aims, or what?
Well, with respect to aims, what I'd say, the test The tech task force is, you know, a group of really smart people who are being set up to look at a series of issues, including, right, consummated mergers, and see whether we ought to think about them differently, kick the tires, if you will, a little, which I think is a good enterprise. That's a question, you know, Leah alluded to this earlier, at which they're looking. What it results in, you know, I think remains to be seen. It's still early on.
Sorry, what did you mean by the kicking the tires phrase?
Sort of taking a fresh look with a fresh set of eyes at issues that are drawing industries and issues that are drawing a great deal of public attention because people perceive, perhaps sometimes rightly, perhaps sometimes wrongly, perceive them as having competition problems.
Hi, Tom Duesterberg from Hudson. I wonder if you could explain some of the thinking at the FTC behind the Qualcomm case. What is the consumer harm? And in terms of your thinking about the technology in general, what does it imply for the overall policy of the FTC towards technology companies that acquire market dominance because of their research and development of innovative technologies?
So I'm not going to speak to the Qualcomm case, which, as you know, is sub judice presently. What I will say, consistent with what I said in the speech, is I hope we take very carefully the sort of historical and economic learning that show that there are times where your market position is determined not by anti-competitive conduct, but by competition on the merits. Some of that is offering better products. Some of that is offering products at lower prices. Some of that is innovation. You know, the patent system, we got a PTO question earlier. The patent system, okay, I'm going to geek out for a minute. So letters patent were issued by the English kings to grant like sinecures, you know, really monopolies to favored people at court and elsewhere to do their business. And that was something that rankled folks in England, which led to the Anti-Monopoly Act in, I think, the 17th century. And it really rankled the founding fathers, who did not like these government grants of monopoly. So our patent system is very specific. It exists to encourage, right, innovation, the progress of science and the useful arts, right, in Article 1. The idea was this made sense as an incentive structure where what you were doing was encouraging innovation. And we still do that today, right? For hundreds of years, literally, ever since I think 1790 or thereabouts, we have protected monopolies for innovation. Beyond that, bad. But the patent system still exists and should exist. So look, I think we have to recognize that some people acquire even monopolistic market share on the merits, and certainly a patent is something that gives you a right to exclude others, a sort of monopoly. But, right, where you engage in conduct that is anti-competitive to maintain that monopoly or to acquire it, that's where you run afoul of the law.
Great. Well, please join me in thanking Commissioner Phillips.